Thank you for coming to the IP Center's third lecture in the AIA series with Judge Arthur Gajarsa. We're particularly fortunate to have Judge Gajarsa with us today, not only because he's uniquely qualified to speak on this topic as a judge in the federal circuit, where he'll be on the front lines of figuring out what this act means for the rest of us, but also as the IP Center's first distinguished jurist in residence, and we're very lucky to have him serving in that capacity. For anybody who hasn't taken the time to sit down and speak with Judge Gajarsa, I highly recommend that you do so. It's a very beneficial and rewarding experience. And I know from my own experience doing so that today's topic, post-grant review proceedings, is something that he feels will be very significant in the practice of patent law moving forward. So with that, I'll turn over to you, Judge Gajarsa.
Thank you, Martin. Good afternoon. I guess it's afternoon almost. Good morning and good afternoon. Today we're going to cover Section 6 of the American Invents Act. Under that section, the inter-party re-examination has been changed and renamed as inter-party review. It's more than just a change in language. It's a substantive change to the Patent Act. And we still don't know what impact it will have because it will take some time before there will be full implementation of what I will call IPR for short. The IPR sections became part of the Act because a number of members of Congress wanted in some ways to make it more difficult to have review, and in other ways to make it easier to have review before the PTO. The effective date of that section, the IPR section, is September 16, 2012. The particular aspects of IPR are different than the new section, which was added to the Patent Act by Section 6 of the Act, which is called post-grant review. There are differences in the filings. There are differences in the evidence that can be submitted for the PGR versus the IPR. As an example, the IPR cannot be filed until the time period for the PGR, let's keep that straight. In Washington, you will find that the alphabet soup takes over the entire city. We always use initials rather than the actual words themselves, especially when it comes to describing what we mean by shorthand. DOD is, for instance, Department of Defense. The Federal Circuit is shorthanded by using the CAFC instead. So you have to get used to that if you're going to practice patent law on a national basis. So the IPR and the GPR are different. GPR is a new section, it's a new procedure which has been added. For some reason, they amended the first section by adding sections A through D, I believe, 6A through D, for the post-grant review proceedings, and then adding the new section by subsequent sections of Part 6 of the Act. So keeping in mind that the post-grant review is a new procedure, I would like to submit to you that we take that first because it is a new procedure. It is also a procedure which is applicable only to patents which are filed under the first to file. If you remember what we had indicated previously on the Tuesday lecture, that the first to file provisions will not take place until March of 2013. So the PGR will be effective as of that time period. But the reason why I want to take that first to explain it is the fact that what you have under the PGR is a procedure which can only take place after the patent is issued and the first 9 months after issuance. So you need to have a pregnant pause there because you have 9 months to take advantage of that procedure. The evidence which is available to be filed in an attempt to invalidate claims of a patent under the PGR are broad. Broader than the challenges which can be raised under the IPR. Under the GPR provisions, you can submit evidence with specificity under sections 102, 103, 112, and the other sections dealing with patentability, the 101, 102, 103, and 112. However, under section 112, you cannot use the best mode challenge to invalidate a patent. That's been eliminated by the Act. The best mode is still required in your written description, but cannot be used to invalidate claims in that particular patent. Now, the threshold has also been changed. Because under the GPR, the threshold is more likely than not that at least one of the claims challenged in a petition is unpatentable. That means that basically what you must do in your petition before the Patent Office is establish more likely than not evidence to support your position that that particular claim is unpatentable under the specific sections of the Act, 102, 101, 102, and 103, plus 112. So it's broad, but at the same time, when you're filing a petition, in order to be successful, it has to be filed with a certain degree of specificity. The aspects of challenging the particular patent validity has to be done by a particularly responsible person. The responsible party has to be identified You can no longer act through a third-party agent. The particular party who is bringing the challenge needs to be specifically identified. And that's for specific reasons. There is an estoppel question as to whether, when you bring an action under the PGR and you fail to bring particular issues to bear, whether in later proceedings you would be estopped from challenging the validity on the same basis if, in fact, you did not raise them in the PGR. It's an issue that I think will create a lot of litigation as to the estoppel breadth. That's an area where the statute is not very clear, and if you go back to the legislative history, which we will need to do in many of these sections, the report of the committee points out that particular section of estoppel in the Act as being applicable, but what does that mean as far as the estoppel issue is concerned? Does it mean that if you could have brought a particular defense and you failed to bring it as the patentee, or if you were the petitioner, if you failed to raise a particular issue, does that mean that later on, if you are challenging that patent in court, that you would be estopped from raising it at that point, if in fact you could have brought that particular invalidity challenge to bear in the PGR? Questions that will need to be answered as to the breadth of the estoppel. But for the estoppel issue, courts might not be in business because the particular procedures before the Patent Office are now almost like court proceedings, whether it's the IPR or the PGR. The director is required under the sections of the Act to specify regulations of procedure. You will be appearing before a 3-person panel at the Patent Office. You're all administrative law judges. They will take evidence that is submitted. There will be procedures that the Patent Office will be implementing by regulation. And the director is required to make those regulations available before the Act itself is implemented in the PGR, which, if you calculate the time period, will probably be anywhere between 14 to 18, 20 months after the effective date of the first to file. So we're talking probably about the PGR provisions to be implemented sometime in 2014. That's when the first patents are probably going to be issued under the new first to file provisions. What happens once the petition is filed? The aspects of the examination requires that the Patent Office provide the parties with a written decision. The decision by the Patent Office is appealable to the Federal Circuit. There's a question in the Act itself as to whether 145 would still apply However, that might be a question that the Federal Circuit will have to decide, because under Section 145 of the patent laws, you can file an action in the district courts for review of the actions before the Patent Office in denying a patent or in validating a patent. Under the Act itself, Section 145 was also amended to provide for the district court actions against the Patent Office to be filed no longer in the District Court of the District of Columbia, but you will be litigating those issues in the Eastern District of Virginia, which, as some of you may already know, is a rocket docket provisions. And the reason for having done that, according to the legislative history, is to provide for the venue of the Patent Office to be available in the Eastern District of Virginia instead of D.C. Patent Office at one time was in Washington, D.C. Made sense to do it in the District of Columbia, and now it's been shifted to the Eastern District of Virginia. But there's a question as to whether or not there are available actions in the district court subsequent to some actions by the Patent Office in that area. One of the other aspects for the PGR is not only do you have to file your petition with certain degrees of specificity, and the more likely than not provision for the threshold issue of filing the petition to be received by the Patent Office. But there's one aspect which you have to take into account. Patent Office charges a fee. The fee for PGRs, once it becomes effective, the fee up to 20 claims is $35,800. That fee can be reduced by the Patent Office under certain conditions for micro companies, small businesses, and small inventors. But it's a hefty fee. And the question that comes up for some individuals who will be challenging some of these patents before the Patent Office, is it worth it? Time will tell. Because in some cases, defendants might not file before the Patent Office. You're not required to. If a patentee obtains a patent and you're the defendant and you feel threatened by that patent, there is an action called declaratory judgment, which you could file as soon as you feel threatened. And as you know, there's been a change by the Supreme Court decisions in this area as to what standing you would have to file a DJ action. But there is an interplay between the filing of a PGR and a DJ. If you file the PGR, you cannot file a DJ. If a DJ is filed and somebody else files a PGR, but you're not party to the action, there's a question as to whether or not the statute provides for the DJ to be held in abeyance until the PGR is determined. One of the advantages of the PGR will be the expedited provisions for a determination of validity. as some of you have traced patent actions in federal courts, it takes time. Although DJ actions can be decided fairly quickly, most patent litigation, including the time period to validity, does take time. In the Patent Office proceedings, there's a requirement that the decision be completed within 18 months. Time will tell. The ITC provisions require the ITC to make its determination in 12 months, make a determination of exclusionary orders. But even those cases have now reached the point where the backlog is such that the ITC cannot meet its obligations. And I suspect that notwithstanding the PTO's willingness to accept this responsibility under the GPR and to proceed to attempt to hire more ALJs, the administrative law judges, what you will find, I suspect, is that there will be developing a backlog even in the proceedings before the Patent Office. The director has hired another 100 administrative law judges, bringing the core of administrative law judges in the Patent Office to 200. That means he can panel about 400 different panels during that time period. However, if the regulations which are being published by the Patent Office, and they will be publishing regulations for procedural requirements in all of these post-issuance proceedings, including the derivation that we talked about the last time, they'll all be covered probably by regulations that will be issued by the Patent Office within the next 12 months. I believe you will find that there will be backlogs that will be developed. Even if, as the director wants to do, hire another 200 ALJs to handle all of the post-examination provisions or post-issuance provisions, that you will find that there will be some backlogs along the way. So the question of expeditious treatment by the Patent Office, I think, is going to be an element of time and effort in the regulations that will be most likely challenged, because the proceedings before the Patent Office, as they develop, will become more and more like full hearings before any administrative agencies. They will be reaching the point where evidence will be submitted, evidence with witnesses will be taken, where in the present proceedings before the Patent Office, oral testimony is not allowed. It's all done by affidavits. I do not believe that under the PGR you will be able to limit the evidence by regulation as to what can be submitted. You will have, there are 13 items which are required by the statute to prescribe regulations governing 13 aspects of the proceedings. Among them are items that seem to contemplate that the conduct of these proceedings will resemble civil actions in court. Documents filed under seal, discovery including depositions and sanctions, protective orders for confidential information, and the right to oral hearing. What does that sound like? That's a civil proceeding in an administrative hearing. It's going to take time. So the backlog, I think the Patent Office, in all good intentions, will try to meet the statutory requirements, but I suspect, and will not be their fault, but the number of items which will be coming forward under these new proceedings will be extensive, even with the filing fees being $35,800. The other aspect, I think, which will come about is that our court, which will hear the appeals from the final decisions of these hearings, will increase the number of cases that we have. Because at this point in time, under the existing provisions of the statute, we hear between 150 and 200 appeals from the Patent Office dealing with the denial of the issuance of patents, the results of interferences, and that includes also trademarks, opposition, appeals, and otherwise. I suspect that under the new statute, just the PGR alone will probably generate between 1,000 and 1,500 appeals a year when the statute is fully implemented. Right now, our backlog is about 1,500 cases. So our backlog will be doubled, I suspect, because of those particular proceedings. Now let's talk a little bit about the IPR, which is the inter partes review. Right now we have inter party re-examination process, which is in the statute, which provides the opportunity for third parties to petition the Patent Office and challenge the validity of patents, which can be done. Under the new statute, the section dealing with inter partes review changes the threshold from a substantial new question of patentability which could be raised to a reasonable likelihood that the requester or the petitioner would prevail. Different shade, a different evidentiary burden. But you cannot file an IPR until after the PGR period of 9 months has expired. The PGR can only be filed 9 months after the patent is issued. And the Patent Office, the director, has the ability to reject the petition that's filed. The petition under Section 311 must be filed by someone other than the patent owner. The petition fee is set by the director, which in the inter party case, it's not $35,000, but it's a little bit lower. The fee for up to 20 claims is $27,200. That's the filing fee. And the petitioner may request cancellation of one or more claims, but the basis for cancellation under the IPR is limited. It's not as broad as it is under the GPR. The cancellation for claims under the IPR for unpatentability is limited to Section 103 and 102. And the unpatentability under those two sections, which is anticipation and obviousness, may be based on prior art consisting only of patents or printed publications. So you have limited basis upon which you can challenge the patentability. The petition must identify all the parties in interest, the real parties in interest. It can no longer be done by an agency basis or an individual attorney basis. You must identify the real party in interest. Once again, because of the estoppel issue, the real party in interest must be identified. And you must identify in writing in particularity the challenge to each one of the claims. The grounds for the challenge for each one of the claims must be written out, and the evidence supporting the challenge for each claim. And you must provide all of the copies upon which your basis for the petition, which is filed, is submitted. Now, after you go through all of this and you file your petition, the director has the discretion not to accept your petition. And that decision is not appealable. There's no appeal rights from the denial of the filing of the petition. Now, I suspect that some attorneys will challenge that on the basis of abuse of discretion by the director. Even though he has a right to deny it, he can't abuse his discretion in denying the filing of the petition. That happens all the time, so you get very good lawyers who come up with a basis for appeal in spite of the fact that the statute says that there's no appeal from the director's denial of the filing of the petition. Why not? Give it a shot. It can always work. You might be able to get the appeal before the Federal Circuit, and you have a panel that will consider the basis of an abuse of discretion. And on behalf of your client, you probably should try that if the petition is denied by the director. The other aspect which also comes about is that the first 4 years after the filing, and the filing date applicable to inter partes review is September 16, 2012. So any action which is filed after that is pursued under the new rules. And the director is getting ready to publish, as I'm told, regulations which will be applicable to IPRs. But during the first 4 years of the action time period, from September 16, 2012 to September 16, 2016, the director has the authority to limit the numbers of petitions which can be filed under these provisions. And the number of petitions which can be filed is limited by the average number of petitions which had been filed during the fiscal year of 2012. So it will be up to the director to determine how many petitions he or she is willing to accept under these provisions. Fascinating new process. And the post-grant type of proceedings, whether they're IPR or GPRs or otherwise, will be grounded in the same procedures. So that means that under the IPR proceedings, you will have the same rules and regulations, which will provide for a full civil action type of process before the PTO. In other words, testimony, witnesses, and otherwise. And these will also be tried before the boards consisting of 3 administrative law judges. The administrative judges will be kept rather busy in all of these proceedings, because if you consider the basis upon the filings and the ability of individuals to at least bring these actions, you can obtain a determination of whether or not your patents that might be assessed against you are valid, invalid, or otherwise. There are a number of procedural aspects which also have to be taken into account, because there's an interplay between the filings of the IPRs and the civil actions which can be brought into court, just like there are between the GPRs and the debt judgment actions, and whether or not in the inter parties there's been an action filed against a particular defendant, and whether or not the procedures are already underway in district court, and whether or not those particular proceedings are involving the same parties that would otherwise be involved in a petition before the Patent Office. And there might be more than one IPR file before the Patent Office. Different individual responsible parties. At that point in time, the director can also make a determination, pursuant to the regulations that will be published, whether or not the petitions can be joined, whether or not the petitions need to be taken in seriatim, and which goes first and which goes second, and which might go third. Might be more than one challenge to a particular patent. But in all of these, you have to make sure that what you have is a case in which the level of the petition itself, and that your burden of proof is a reasonable likelihood that the petition will prevail. So from that perspective, the issues that are presented to the board and to the PTO need to be very carefully analyzed, carefully thought out, just like you would be planning to file a civil action in district court. Once a decision is final by the board, then you have the right to appeal to the Federal Circuit. And even the IPRs, which are very similar to the present re-examination proceedings, we don't receive too many of those cases. But I suspect because of the changes in the law, the Federal Circuit will be receiving more and more appeals, because I believe that most people will take advantage of the new procedures that have been structured by the Act. The Act is complicated only in the sense that it provides for the procedures that have to be followed before the board, and you have to consider the board to be very similar to other administrative agencies where you have one administrative law judge taking evidence. So what the Act really has done is shifted the consideration of evidence which is submitted to the Patent Office, and it's become parallel to other government agencies in which the evidence is submitted by live evidence, by live witnesses. It's no longer just a written statement of affidavit or written positions taken from witnesses and filed under oath. You have the right to cross-examine witnesses, and you will be doing that before a panel of 3 judges. In most other agencies, if you've taken administrative law, you will know that the administrative law judges take the evidence, and then they will file a preliminary decision. And that preliminary decision goes to the commissioner or commissioners in that agency. And those particular actions are then, when they become final, are appealable to the courts of appeals. What they've done with the new act is essentially parallel that process, but instead of individual administrative law judges taking the evidence, you have a panel of 3 judges to proceed on that basis. And once their decision is issued, it's final and appealable to the Federal Circuit. Questions? Any questions? Must be a few. Yes, sir.
I have a question. So a couple of months ago we had, it was basically a former lobbyist for small businesses and also universities. And he was very much concerned that under the new AIA, that these post-grant proceedings are going to basically foster uncertainty for the patentees because there's such a long period in which they can be challenged at the PTO. Do you think he's onto something there? Or?
I think the individual patent holder, if you're not part of a large entity, is not necessarily at a disadvantage, but he doesn't have, or she doesn't have, the same type of abilities to go through the administrative system than you would in a court of law. In situations like that, obviously the first 9 months after the patent is issued, the GPR takes place. You have those 9 months that need to be passed before you can bring the IPR under the new statute. What I will say is that I suspect that any individual patent holder will be advantageous to him or her to file a civil action if there's sufficient grounds to bring the action before a district court to enforce the patent. You will find that individuals will probably be easier for them to bring the action than wait the time period, because once the time period has expired for the first 9 months, then the IPR can be brought. But before your patent is challenged, if you file an action, then there's an interplay as to whether that action is going to be held in abeyance while the administrative proceedings take place. And to me, it's better to be in district court if you're a small inventor than before the administrative agency, unless you are of the judgment that you can defend your position clearly in the administrative agency in the same way that you would in district court. But I think that if you want to enforce your patent, you ought to file as quickly as possible, obviously with the requirement of due diligence and the infringement requirements of an analysis before you file the action.
Offensively or defensively? You've got the district court actions and the infringement when you just described declaratory judgment actions. Each time you mentioned it, you suggest the district court might hold its action in advance. Are we just talking about some kind of discretionary stay? Are they worried about collateral estoppel?
The only automatic stay which comes about is a deck judgment action, which is filed during the 9-month period. So if you're able to bring an action in declaratory judgment challenging a particular patent because you feel threatened by it, that particular stay is automatic in the first 9 months. If somebody then files a GPR.
So the PGR clearly has primary jurisdiction, so to speak.
Over a deck judgment action, because a deck judgment challenges the validity at that point in time. But it's not, if you're the patentee and you file an action for infringement, I think that would take precedence over the GPR. Because you're at that point not challenging the patent, you're saying you're infringing my patent.
And you have the statutory presumption of validity.
That's right. That still exists, which is a strong presumption of validity at that point, which has to be overcome. That has not changed at all by the statute, thankfully. Patent system does exist, and hopefully it will be a stronger one because of this.
This kind of timing, I guess, because also you have that 9 months, you have to file in that 9 months. But also if a case was also filed in court at the same time, and I guess the patentee filed it, perhaps. But if a Markman hearing was done in the federal court, and whatever the results were decided there, how's the patent office going to accept or take those? I mean, it could certainly be presented as evidence, I suppose, but... You
could present that as evidence during the proceedings if you wanted to. And, they could give them weight, but persuasiveness,
yeah.
Who knows? That's a question that's going to have to be answered.
So what do you do a Markman hearing? I mean, is it
exactly. And I think that the Markman hearing, I've always been of the opinion that in order to cut some of the costs in litigation, you should have the Markman hearing as early as possible, with the right for interlocutory appeal to the Federal Circuit. That, I think, would cut back a lot of the legal costs incurred today. But we don't allow that, so, which I don't think is the proper procedure.
So, Your Honor, from your perspective, or from the bench's perspective, there's no difference really once you get into the IPR that district judge, he can, just like with a re-exam now, he can decide to stay his case because the lawyers convince him that that's the appropriate place. Or, again, depending on the timing, he could say, nope, we're going forward. So there's no difference. What would be the perspective from the bench? Would it change?
I don't think it really changes that much. I suspect what you're going to have is the filing before the Patent Office. There are some interplay between the two, and those still have to play out. And I think that if the Patent Office wanted to proceed, because you can get a decision reasonably quickly out of the Patent Office, hopefully you can after all of these cases back up on it. But just like the patent application, once they back up, it's tough to work down that backlog. So instead of 12 months, 18 months, the provisions are for 18 months on the outside. But I think it's going to take longer than that once you get into the full swing of the ability to bring the IPRs and the GPRs. It's going to be a backwash.
So a key question for a district court judge would be, how long is that going to take?
That's right.
Because he doesn't want to stay in case on his docket for years.
But there are sections there where, in some cases, you can give discretionary authority to district court in making that determination. A lot of judges, what you'll find is that if there is a experienced government agency with the experience that the PTO has, some of the judges will allow that to be held in abeyance until the agency decides because of their expertise.
Well, that's currently what my experience is,
Right.
and I was just wondering with a sort of what looks like a heightened, almost civil action proceeding going on here, it would seem that judges would be more likely than not to let that
That's right.
occur, even more so now.
Unless you get into those judges that like patent cases. And there'll be more of those because of this new pilot program which is taking place right now. There are judges that have asked for patent cases. And there's a pilot program, I guess in about 15 different regions of the country, that will be taking more patent cases assigned to them. Questions? You get a shot at a circuit court judge, doesn't ask any questions. Can I ask questions?
Is there any provision for handling like 2 or more related patents in a single proceeding?
There are. Those will be covered by the regulations too. I think that they'll probably establish it in such a way that if you file 2 separate petitions, you have to file 2 separate fees too. So those fees become pretty hefty because the fees allow you to bring challenges against 20 claims, whether it's a GPR or an IPR, they're both the same. And you can't file the IPR until the 9-month period has expired. So the question then becomes, if you file a GPR and the GPR is still ongoing, can you file the IPR? You can't. You have to wait until the GPR is completed before you can file the IPR. That controls the time period too. One time in the original legislation, the GPR time was 12 months, and then they cut it back by compromise to 9 months because it does stay everything else. And I think what the intent there was to force the procedures to be tried before the patent office, giving them the authority to try it almost like a civil action. It should be interesting to see what happens once it becomes fully implemented. Any other questions? Chris?
Oh, sure. Just as your best guess, how much would you say these procedures are going to be used? I mean, what we've seen with inter-parties reexamination over the past few years is that it's relatively rare. The estoppel issues really cause a lot of people to pause before undertaking such a procedure, and I think that the same estoppel issues are going to be present with these procedures. So, I'd expect that the uptake on these is going to be slow. The question is, in your opinion, eventually, how much are these going to be used as opposed to civil court cases?
It depends on how quickly the patent office can get a decision on.
Okay.
If you can get an expedited decision on particular validity matters on a patent, and you can get that within 12 months, why wait 4 years to go through a civil action? If you can get that same decision, which is essentially a Markman type of a hearing, done before the patent office.
Sure, but if the backlog grows so that you've got
that's the question.
2-3 year backlog, then you've got to weigh the uncertainty due to the estoppel issues, at least until there are decisions on exactly what the scope of that estoppel will be.
If the patent office can proceed on the basis of the expedited determinations, a lot of people will use it. If it starts getting backed up, then why bother with it? Because the patent office can't give you damages.
Right.
They cannot issue damages. So, and the question that really comes up also, is this going to provide an avenue for the big guys to go against the little guys? That's my concern. That it might give the larger operators the opportunity to challenge patents obtained by the individual inventors and even by universities that might not be able to withstand that kind of a barrage of legal fees or costs and uncertainty. I don't know. But I suspect that might come about. Even if the Patent Office is able to hire 400 administrative law judges, that might keep them in balance for a while. But if people see this as an avenue of getting a result very quickly, you'll see more and more of them coming about. Because it's a quasi-Markman proceeding. And you can look at it from that perspective.
If the big guys do go after the little guys, what you suggest, can't we look at this as like a trial under fire? And now the little guy has a great patent that's made it from an Apple or someone coming after them?
Oh, if they succeed in defending it before the Patent Office, then you'll have a much stronger patent than you would otherwise, because it is a trial by fire. But the question that comes about there is whether or not, when you hire a patent attorney to defend you in those proceedings, whether the costs are going to be expensive at that point.
I would think from a licensing perspective that future licensee argue that I made it through the post-grant review procedure, maybe make up some of those costs.
Make it up. It's a good way to do it. But that's just my own personal opinion, that you might see the smaller individual inventors not able to withstand the barrage of costs that come about.
I just realized that this gives the potential infringers the right to initiate, even when there isn't enough threat for
Oh, that's right.
judgment.
Yeah.
So the whole choice is when or whether to start infringement actions to enforce the patent. Now I understand why the smaller person doesn't want post-grant
Review.
because they can make their own mind up if they want to go to court.
That's right.
They don't get to make their own mind up during those 9 months.
But you have to overcome the discretionary authority of the director at that point, because he will assess whether or not you have the evidence to surmount the initial threshold.
Do you think that the post-grant review will be favored over district courts because the administrative patent judges have a background in this technology of the patents that are being challenged, as opposed to the federal judges that probably don't?
To whose advantage is that?
Yeah. You think that will favor either side?
I don't think so. We have a lot of district court judges that have no technical background who are superb at handling patent cases. As long as you have good lawyers that are able to explain the technology, I don't think that the ALJs are going to be any more experienced than some of the patent examiners. And relying on their expertise, they might decide that they know more than what the evidence shows. But you're right. Most of them will probably be technical people with technical knowledge and background, which might be helpful in expediting the cases too. But I'm of the opinion that technology is as good as the lawyers explaining it to the court. And if you can break it down in very simple common denominators, most judges will understand it. It's the question of whether or not the attorneys want to muddle it up so that the judges don't understand it at that point. That's where the ALJs might have an advantage.
If the PTO pulls in several hundred ALJs, are they paid? Are the judges paid through like PTO fees? And if that's the case, won't fees increase? And we already have several $1,000s worth of fees for these procedures. And if that's the case, people might not think it's worth it. So how do you find a balance between like number of ALJs to pull in and what types of, like how much to charge for fees?
Oh, the judges are salaried. Their fees, their income does not depend on the fees that are charged.
Okay, but with these fees that are charged, doesn't that have an effect on like the amount of people the PTO can employ?
Yes, it does.
Okay,
Yes,
so I
it
guess
does.
just like where do you find a balance between how much fees to charge and how many PTO employees to have?
The fees are statutory in many respects. Some of them are set by the director where he has the discretion to set it. The fees go towards the budget, offsetting the budget of the PTO, including the salaries of the employees of the PTO. Any surplus, and the PTO has been running a surplus over the past few years, is put in a special fund, and that cannot be spent without the approval of Congress. So it doesn't behoove the Patent Office to increase their fees just to have more of a surplus unless they can spend it. And they can't spend it without the approval of Congress. They still have to go in and get a budget approved by Congress. And their fees are offset by that budget. So if they have fees which generate, let's assume $1 billion, and their budget is $800 million approved by Congress, all they can spend in the operations of the Patent Office is $800 million, not the $1 billion. The difference is put in a fund under the statute and can be spent only with the approval of Congress. And the problem has been in the past that those fees have been going back into the general treasury and not being used to improve the patent system in the United States, even though the patent applicants pay those fees. That's a big issue. The director tried to get the authority to keep those fees to improve the system of the Patent Office, but the Congress wouldn't let him. It's not fair, but that's the way it is.
That's a question on validity. So if a patent is in the PGR, it's valid until the decision, and at that date it is invalid. But everything is public, and so you certainly, as a patentee, you're at risk because the question is, you just had a patent issued and at the same time
Somebody's challenging.
somebody's challenging immediately,
Right.
which is so. But that the invalidity, if it is decided, that would also be immediate. That
Right.
you would lose that date of decision.
That is that decision, right?
So, yeah.
So the issue really, the intent was to try to make sure that the patents which are enforceable and enforced are valid. The attitude of some members of Congress is that we have a lot of patents that are invalid, that are just hindering the ability to innovate. So the more patents that are held invalid on the basis of the statute, the better off the country will be. But I wonder about that too.
If it just got through the patent, it's valid, right?
There is a
Just
presumption
issued.
of validity.
Absolutely. So that's, yeah.
It should be.
So it's a question, someone else is bringing the case on the government, but at the same time, wait a minute, you guys were wrong. You should have caught it earlier. Or,
They get to jump on the inventor before the inventors had a chance to make it money.
That's right.
That's so cool.
Yeah.
Yeah. Yeah, and the attitude that some of the members of Congress have is that they hear all these stories about patent trolls and non-practicing entities and patent thickets, some of the other aspects that, according to them, without really understanding the system, hinder innovation. I don't think that's what it's hindering innovation. I think there are other elements that hinder innovation. Any more questions?
So the post-grant review accepts a broader evidence when challenging a patent, and according to the broad definition of the 102 section, you can invalidate a patent on the basis of worldwide public use or worldwide public sale. So how do you think if a foreign corporation or a foreign entity would want to invalidate, or rather not invalidate, but challenge a patent in a post-grant review, how would they submit evidence of use or sale in their country?
Well, they would have to show that they would have to do it by documents and witnesses. You have the right to submit any evidence which would support the petition. You have to file a petition first. You have to do it with a degree of specificity so that the commissioner or the director can decide whether or not to allow the petition to go forward. But there's a first cut right there. So you have to really show, whether it's 102, 103, or otherwise. Under the PGR, you have a broader ability to bring evidence in under 101, 102, 103, and 112 than you do under the IPR. So it's just a matter of evidence that's submitted at that point in time. And it is worldwide evidence.
With these fees, do you think when these fees come into play, do you think we'll see an increased hike the cost of tuition to schools to try to compensate for the fact that they now have to? I mean, fees are going up already to get into schools, and now you're going to throw in this fairly expensive process. Do you think that they're going to be passed? That it's going to get passed down to the
schools,
public, as far as researchers?
Well, your research costs might go up, but your patent application fees have gone up too. And I don't see any real relationship between tuition and those particular costs. But universities have done more and more research over the years, and many of them are using their patent portfolios as income, and the smart ones are using it to increase their research, and some of them are using to give scholarships. So you get an offsetting aspect of that to individual students. So when I wrote Mayday versus Duke University on the experimental use basis of patent technology, I had to do some research on the amount of income which the universities were getting from their patent royalties. The California system at one time was getting $750 million a year in patent royalties. That's a lot of money. Duke, for instance, was getting over $4.5 million a year from patent royalties, and that's gone up because the universities have started to use their patent portfolios for licensing and for other development. And if they use that to increase their research, that's, I think, a good way to do it, but they should also use it for scholarships.
So we've seen the ever-increasing importance of the ITC in litigation in general. Can you just touch on briefly the interplay between the post-grant proceedings and future ITC litigants, if any?
ITC?
Yes.
Well, the relationship is going to be in such a way that you have to really read the statute and the regulations as to how that's going to play out. But the ITC was always looked at as a backwater agency until people realized that that was a good way to get an action brought within 12 months and you can get an exclusionary order to keep the product out of the United States. And if that was done within a 12-month time period, that's a great way to prevent your competitor from competing with you in the United States. But what happened there was that it became such an expensive process over the years because of the 12 to 18-month time period. You have a lot of firms that throw 20 and 30 young associates into the cannon fodder aspect of trying to put all the evidence in an ITC proceeding. That 337 has become not only a tool, but also not a defensive tool, but an offensive tool by a number of corporations. I think the interplay between the PTO's proceedings and the ITC will have to play out to see what happens, especially if the PTO can keep the 12-month schedule online. Basically, if they can get their decisions out within 12 to 18 months, they'll compete with the ITC for business. Thank you very much.